Joshua Rosenberg.
Over here.
Okay, hey, how are you today?
I'm doing better because I was on the streets and it was cold, and now I'm in jail and some good food, and I'm
Well,
just.
I hear it's actually cold in the jail too, but it's warmer than it is outside.
Oh no, it's great. It's great. I'm almost 50, so I need to. This is my little retirement home for right now. So
No. So from November 7th, it's called public intoxication, fine range $1 to $500. Court
This guy's full of silver linings.
costs are $81. Are you wanting to plead not guilty? Come see me to set it for trial or to have time to hire an attorney? Or do you want to plead guilty or no contest?
what was the charge again? Public intoxication or?
Yes, sir.
Oh no, I'm guilty as fuck, Your Honor. I did that shit.
Okay, on your guilty plea, finding court costs is $484, $150.
I don't got all those monies. I don't have any. I have like less than $5. So I'm just gonna wipe my ass. It's gonna grow, and then it's gonna. So what the fuck? Want me? I'm homeless. You want $350, woman?
Let her talk.
Okay, there's no reason to be angry. We have some choices to make. Okay.
Well, thank you. Thank you for letting me know how I'm supposed to feel. The Bible says the fruits of the Spirit, blah, blah, blah. There is no law. You can't tell me how to feel, woman. Of such there is no law. Yeah, I can be angry. God gave us emotions. I can be angry.
Okay. Do you want to hear what your choices are?
Is one of them go back to my cell and lie the fuck back down?
Okay, we're not going to cuss.
Well, you said we. Then speaking I statements, because that's part.
I'm not going to cuss, and
I'm allowed to cuss. I'm allowed to. I'm an adult.
Okay. So the choice is you would be released today to appear on Monday to talk about how to pay it. We talk about all different ways, including community service. Or you can voluntary remand and sit it out. And I'll see if we can't get a TPC caseworker to come and talk to you about maybe some rehab potential.
Yes, ma'am. That's second option, ma'am.
Okay, so you're going to sign a document in the back with that officer called voluntary remand. As soon as you've sat out, let's see, 384 divided by.
He literally wants to stay. That's it. He didn't realize he didn't need to be a jerk to do it. He could have just nicely said, "I want to sit it out." But he's cold and he's just happy to have shelter. That's clearly what's going on.
150. It'll be another 3 days starting tomorrow. So Sunday, Monday, Tuesday before you're processed out, because after that, your time served.
Yes, ma'am.
Any questions?
No, thank you.
You can return to your pod, but sign that document that he shows you.
And I'm sorry for being so mad. I'm not mad at you, but I am mad.
All right, I understand.
Yes, of course, this is Zach's fault. Leonard's Unite.
And you have back to your bottom.
Concrete Place versus Singrid Melvin.
I had this yesterday, but I thought it was too cranky for a happy hour.
Go ahead.
Good afternoon, Judge. May it please the court, Mark Wasbury on behalf of plaintiff.
Your name?
Sigrid Melvin.
All right. I am almost afraid to ask, where are we?
Well, Judge, a couple things. We have scheduled the contractor to do the glazing in the kitchen next Thursday. So by Wednesday, we need everything cleaned out from that area so he can do his work.
Okay.
There's
For those of you who don't remember, this is the old lady who wanted to have pots on her balcony to grow tomatoes. There was mice. It's a whole situation.
still some items that need to be addressed on the balcony. I don't know what the inside of the apartment looks like. I believe this is her son with her, helping her on those issues.
You're her son?
Yes.
Okay. No, okay, go ahead.
That's it. We want to get
That's
into
it.
the glazing. We want to see where we're at on the inside, and we want a couple things addressed on the balcony.
Balcony. Okay.
Okay, Monday, I got a call from Young.
Mrs. Young,
That she,
is she here with us? Yeah, she was here.
I am here. I am
Okay,
here.
she was here the last time
Yeah,
in person.
yes.
okay.
She wouldn't talk to me for a longest time. It was horrible. No, I'm kidding. All right.
Since I called her back to get an update of what was going on.
Right.
I think you guys were out there Monday after the war. They were gonna take some of her possessions, but in Tupperware. But to put the Tupperware anywhere.
In fairness, I actually skipped an appearance because it's kind of sad. But I also feel like I should update it.
In the apartment, it would still be in the way. Tuesday, I went out there. Big issue, then taking up the room in the apartment was 3 bookcases of books. With the previous management, we had kind of the same issue because the bookcases were in the hall. They were taking up room going towards the bedroom and the bathroom.
Got it.
At that point, they said it was okay to move them into the living room behind the couch.
The previous management said that.
Yes.
Got it.
We're happy with that. We have new manager in the building. I went in there, I took out the bookcases, all the books. I had pretty much a pickup truck load of books. She has a lot of old books she has
Mm-hmm.
of that. So all that has been done. We arranged
I'm not sure. I think this is her son.
everything.
Okay.
She has
Okay, who's this person?
Like with the Housing Bureau for Seniors.
Got it. Okay.
I do have pictures. Like they weren't able to make it inside, but she did a great job.
And anyways, I went out there Tuesday, all that cleared out, Wednesday, went over, rearranged more stuff. When I went out there Tuesday, I did stop in the office and told them what I was doing. And, Renee, she was like, just let me know when you get pictures. Okay, so I did my thing. Thursday, yesterday, I went out there to the apartment center, went in the office and she was in there. I asked her, have you been up there to get pictures? She said no. So, and at that point, she took me in her office. She gave me some paperwork she wanted my mom to sign to adjourn today's meeting.
This hearing, you mean?
You know, they weren't in court papers or anything like that, but I'm not declining that. The balcony, we did clear off some of the additional pots that were up there.
Got it.
My point went out there yesterday. I figured you'd go up, take your pictures, and if there was more stuff, more issues, I would know at that time to be able to take care of it. The glazing is really not a problem or an issue. We talked about that yesterday. I'm like, let me know when they're coming. She told me to let her know my counters were cleared up. It's basically anything on the counter or kitchen has to go in.
Let me just stop you there. They're coming on Thursday.
Yes,
Next Thursday.
a week, about six days from today.
Got it. No, they're coming on the 13th.
Yeah.
All right, they're coming on the 13th. Does she, when you do that, does she listen?
Huh?
What were you gonna say?
I have a piece of paper in my bag where it says, they've been coming August 2024 to do that.
Okay, we're gonna get it. We're doing it now. Okay?
I'll be out there on Wednesday. Get the stuff moved.
And
Any questions about that as far as reglazing? they're not actually taking the countertops off, they're just re-laminating.
Correct.
Okay. All right.
That's the difference.
Yes, it is. All right. So
And
go ahead.
then if there's, I know, I was looking at the table and the bench on the patio, and it's like, I told her, it's like, I'll get rid of those and get you a new one for your birthday, but if there's more additional stuff up there, she did come over and take pictures. There is quite a bit of room. So the question was access from the door.
Right.
Balcony. Everything around the table is cleared out. The couches is much further back. So the thing about that table is that's their dining room table.
Got it.
Towards the couch, where she can sit on the couch and eat. On the other side, there's plenty of room, no papers, boxes. If you'd like, you could look at her pictures.
Okay. Hang on just one second.
Or if he wants to look at them, see if there's
Yeah.
a nice factory.
Well, and my client would like to, next Thursday, when there's set aside time for the glazing, she would like to go in and look at the inside. That would be a great time to.
I think that would be a great time without disruption.
And then I'm also given a picture, it was taken today. This is the balcony.
I can get anything done, yes.
Okay, so I'll just sort of tell everybody what we're looking at the balcony. There's still off to the left-hand side, there's something hanging. I don't know if those are lights or, well, we're not supposed to have anything hanging.
No,
That's not even a plan.
TV antenna.
That's her TV antenna. I
Oh,
thought we had clarified that.
well, that's different. Some, just to the right of that is a baker's rack and then something hanging.
Oh. Yeah, what are those?
That is, all the way to the left, it's like a cast iron trellis that the plants grow up.
Right. I see that, but then there's something, if you look up at the top of the balcony, it's like there's a hook there or something, and there's something hanging from that. It looks like it might be lights.
Yeah,
Yeah,
that's the Christmas lights. I haven't taken down yet, but
You haven't gotten them down yet.
yeah.
You told me you were going to take them down. You'll get them down, right?
Well, the hook is very high and I can't reach it.
I'll get it.
Okay, but your son's now working with you, so he'll get them down, okay?
Right. No problem. There ain't gonna be no Christmas this year. Christmas lights up and my neighbors, they got the lights up already.
No, don't tell her to. I get everything she's saying, so we just have been determined, okay?
I heard the last few cases go on and on.
May I have the floor for a minute? When I came here the first time, I bought you a bag with nice stuff.
With the mice stuff.
Right.
Yeah, no, I remember. We made sure that stayed out in the hallway.
Mice are still in my apartment. I found 2 dead ones yesterday.
Okay, so here's
Nobody is coming to pick up the mice or change it and clean it up.
okay. So here's
Fun.
okay. Listen, here's what we're gonna do. Okay, hold on. Remember, there was the issue, okay, of trying to just get through to get some cleanup in the unit. Okay, but now that process has begun and is happening, then we're going to address the mice issue. Okay, but I want to make sure this first part is done and we get through that. Okay, I promise you.
I've been cleaning the apartment for over 5 months, looking for the mice. When the exterminator comes, he doesn't even bring the tools to catch the mice.
Okay.
And I'm nervous, like, because when I get up, first thing I worry about, am I going to step on it or what?
Ms. Melvin, here's what we're going to do.
Yeah.
I want to get that done. I want to get the balcony in its position because remember, your hanging pot only has about 8 more days left.
Yeah, well, it's the end of the season.
I know, but it's got about 8 more days. I let it stay there till December 15th, so that you know that hanging pot has to come down to 15th.
Okay. Oh, what date?
It was the 15th. I gave you to December 15th.
December. Oh.
Yeah. Oh, that's right. No, it's got more time. I did put it in December, didn't I? Oh, no, you got about a month and a half. It could stay there.
Okay.
All right. Yeah. All right. Pardon?
Countertops are next.
Countertops are next week. Get the light down that's hanging, the lights that are hanging down. Then what I'm going to do is I'm going to adjourn you out a week. Okay? I'm going to adjourn this 1 week. So you'll come back and see me next week. By that point, the glazing will be done, right? The light thing will be down. We'll see what other issues there are left. And then if we have time, we'll talk about the mice, but also the landlord can then look at the unit on Thursday before you guys come in.
You've been coming in and out of the unit without me knowing them or letting them in.
Okay, I presume they have a purpose, but we'll deal with that after we get this first part done. Okay, Miss Melvin?
Yeah.
Okay. Anything else for you?
Yeah.
Okay.
When I went to pay the rent, she wouldn't accept the check. Well, she did accept the check, but then she put it under my door back. And the same thing this time, when I went to pay the rent, and she is my witness that I paid.
It's because of the termination. Is that what's happening?
Yes. And my client said she's gone next Friday. She will go in there Thursday, take pictures, give them to me.
Okay.
May I appear by Zoom next week?
If you send in the form, I don't think I'm going to have a problem with it.
Okay, thank you.
All right. Okay. So that's where we're going to do it. Now, how many months have they not accepted of her rent?
2.
2 months? Okay. Do you still have those 2 months of rent?
Of course.
Okay, so here's what I'm going to order, because this way, if I order it, it's not a Park Forest issue. You paid the 2 months of rent to them. I'm ordering that the plaintiff accept it. Okay? And that way, that's not a leftover issue that we've got to try to clean up. Fair enough?
Fair enough. Also, my mental and health condition isn't particularly the best, as you can see. I have a blood pressure over 200 every day and 103. So I can't take any more. So I've been there since 2 hours.
Okay, I know. All right, Miss Melvin. Just listen to me. All right. Ever since you've been coming here, you were really worried about that they were somehow going to kick you out and they were going to do whatever, right? And one thing I told you and I promised you is I wasn't going to let that happen unless it's absolutely necessary. And right now, it hasn't happened. So what I want you to do, we're just working through these things.
Okay.
So what I want you to do is just relax. I'm not going to let anything happen until I say so. And if I have to have something happen, I'm going to explain to you exactly why. Because that's what I've been doing, right? When we go through it. So I don't want you worried about anything like that right now. You hear me?
Yes.
Okay.
Thank you very much, and God bless you.
And the same to you, Miss Melvin. All right. And we'll see you next week. What time? At 2 p.m. Yes, sir.
Get off work at 2.
Yes. We'll do 3. They can appear via Zoom. We can do 3 because I appreciate you and everything you've done for your mom.
I know that's it for you now, but
All right. Okay, Miss Melvin, take care. Yeah.
Thank you, Your Honor.
Thank you, man. You have a great weekend.
Yeah,
Fixing
that case used to be fun.
housing 401k plan versus Erica Ward.
That case used to be fun, but now it's kind of a bummer. This one is just contentious. They really don't like each other.
Good afternoon, Your Honor. Steve Otherly on behalf of Plaintiff Fixed Housing. Okay.
Donna Tope, appearing on behalf of Eric and Aaron Ward, the tenants on the lease.
All right. I'm almost afraid to ask, where are we?
Your Honor, I believe procedurally we're at this would be the first pretrial hearing because the
Yes.
first hearing was adjourned because Ms. Tope was out of town.
Yes.
Well, I didn't sign the order, but yeah, it was adjourned. However you want to look at it. Yes, procedural. Go ahead.
Your Honor, tenants Erica and Aaron Ward own and operate a horse boarding farm on the property. Under the lease, tenants are required to pay base rent of $5,500 per month without any deduction or set off whatsoever, and that's paragraph 3 of the lease. Tenants, what really kickstarted this dispute, tenants set off $2,800 from the June 2025 rent when they unilaterally placed the hot water tank on the property in violation of the lease. Tenants have not paid rent since August of 2025. From my knowledge, tenants are supposedly placing the rent in their attorney-client escrow fund. They're paying contractors and for supplies with the rent money owed to landlord. Tenants are operating their commercial horse farm rent-free on the property during the pendency of their circuit court action. Tenants admit to withholding rent, so there's really no factual dispute here. Under the lease, paragraph 19A-C, the lease allows landlord to terminate and recover possession of property. Right now, I believe the base rent owed is $24,800.
24/8.
Yes, $24,800. Or if you want me to get into the procedural history, because there is a circuit court action that was filed.
Well, I was just going to ask about that. Go ahead. I'll get back to you. Let me just. What about the circuit court action?
Your
Is
Honor,
it between the same parties?
it's between the same parties with an added party, Willow Ward Equestrian, which is the business that operates on the property.
Got it.
That is the horse boarding farm that the tenants own. So in June 13th, on June.
Can I just ask,
Yes, Your Honor.
what is the general subject matter of that circuit court action?
The general subject matter is they filed the complaint and they're alleging that landlord, my clients, didn't make certain repairs on the property, and we dispute, the obligation under the lease agreement. But they're still not paying rent. And under the lease, it has that without any deduction or set off whatsoever. So they brought these claims. It was a race to the court, and tenants filed a circuit court action. And then we were forced to answer and counterclaim for breach of the lease agreement, breach of the guarantee, and we brought a tortious interference claim because tenants have been preventing my client from selling the property. My client's been trying to sell the property, and given their operation on the property, that's been an issue.
Who is that case before?
That case is before. I apologize.
Judge outside.
Judge outside hasn't?
Judge outside.
Okay.
That's correct. Yeah.
All right.
So after landlord filed its answer and counterclaim, we filed a motion to compel payment of rent in August, but the court's earliest scheduling date for that was last week. So we've gone all of this time where tenants are operating on the property rent-free, and my client has its own financial obligations that he's not being paid for, but they're still operating on the property. And just because they filed a circuit court action does not insulate the tenants from defaults under the lease, and also doesn't bar this court from exercising jurisdiction over a summary proceeding.
So, Donna Tope here.
Here we go.
You do have hearing that sometimes I'm not able to hear quite well. So I would appreciate that. Your Honor, I know that you are a very thorough judge, and I filed an answer to plaintiff's complaint to recover possession of the property. And in that answer, I listed out the situation that led to our filing a breach of lease complaint in the circuit court that is being heard by Judge Alzai. In my answer, I stated that the defendants leased the property at 2801 West Delphi in Scioto Township, Ann Arbor, Michigan. The lease began May 1st, 2021 and ends May 1st, 2028. The property has, and it states so in the lease, has been used as a horse farm. It's zoned agricultural for over 25 years. It has had an indoor arena, showing arena. It's a showing boarding facility. When Fixing Housing purchased the property on a land contract from the former owners, the lease with the wards continued that operation, that it operated as a horse farm. So this is a little different than most landlord-tenant cases, Your Honor, because while Aaron and Erica Ward are the tenants, the place needs to be made healthy, safe for the welfare of not only the residents and the people who board their horses there, but also their horses. They have over 35 horses. So those are the beneficiaries of the landlord's duty to keep the premises under safe repair. About a year and a half ago, Erica notified the landlord that several of the outdoor sheds that shelter the horses during snow, sleet, the torrential rains we have 24/7 had deteriorated to the point where they fell down. A windstorm blew several of them down. They were no longer sheltering the horses, and the debris left by the destruction of the shelters was unsafe for the horses in the pasture. Erica Ward notified the landlord, asked for repairs. He did not respond. He also then went into the pastures because he has had it on the market. In the lease, it says that that it's invested, and he wanted to be able to show potential buyers and host events at the property, which he has not done. But he was looking for septic fields, and he had a bulldozer enter every pasture and dig with a bulldozer down 2 or 3 feet to see if the property perked for septic fields for development. It did not. He did not repair those. That is unsafe footing for the 35 horses that have to be out in the pasture 24/7, and they need safe footing. What started this current action, she also asked him to repair several other things. But what started this entire action was about June of 2025, the spigot, which supplies water for the horses, and they need a lot of water, needed repair. It was leaking, and it was going to burst and be unfunctional. She asked him to please make the necessary repairs. He did not make the necessary repairs. Aaron and Erica made the repairs themselves. They also the hot water heater that provides hot water for the horses to be able to have their poultices for injuries.
But all of this is a result, it was in the circuit court action, right?
Yes, but it's under breach of the lease. And so what started this was that they asked for the hot water heater, which had failed. They asked for the hot water heater to be replaced. It's necessary for the safety of the horses.
But
and
what
people.
about the provision that the base rent is going to be paid without deduction?
So that is if they live up to all of his responsibilities.
Conditional? That's not what I read.
Well, it is not conditional, but in any contract where one party breaches several.
I have two businesses, in essence, that have entered into a contract. That contract can read various different ways. I mean, you're trying to say that there's a general reading of a contract. Maybe if it weren't two businesses operating at arm's length, you might be correct, but that's not what I have.
No, we have a lease, and under Michigan landlord tenant law, which I have researched with the Michigan State University Law School and the University of Michigan, the city of Ann Arbor.
Law school? They have one?
They absorbed.
I dig it, I'm sure.
Okay, well, they do have one, and they give really great advice to their student tenants. And one of them is that if necessary repairs that affect the habitability, the safety, the welfare of the residents who are under that umbrella.
Where is that base rent?
So in June, they notified him to please repair the hot water heater. He did not. They repaired it themselves. They withheld the cost of the hot water heater. Aaron did the labor installation himself. They paid him the difference between that withheld for necessary repairs that the landlord is duty bound to provide under the lease, and gave it to him.
That's June.
That's June.
So what happened in July, and where's that rent?
Yep, they paid it.
August.
We started withholding in August 1st. In July.
So, all right. No, not really.
No.
You
Okay.
ever do that to me again, you'll be out in the hallway.
Thank you. I apologize. I was not trying to.
August, September, October, where is the base rent?
The tenants told the landlord that they were going to have these things repaired, and that they were going to withhold the rent to make the repairs.
Why can't I just get an answer to my question?
And after they notified him, he had threatened to take over the farm, insert his own manager, and they paid the rent into an escrow fund, out of which the necessary repairs were made. They withheld the rent to make the payments to the contractors that were filling the dangerous holes in the pastures.
Where, out of what account?
They paid the account into an escrow fund that I held for them to be able to pay the contractors for the necessary repairs.
Like the last case you were here on, now we have a problem. Because either you're going to be a witness or you're going to be a party to this. We ran into this the last time you had a case before me.
Your Honor, I was their attorney, and this was the only way to be able to get the repairs done that had been necessary and posing danger to the horses, the residents.
You're playing, it's one thing if the attorney is using their trust account to hold funds of their client. Right?
Yes,
These were not client funds.
yes. They were the client funds that were to be used to make the repairs for the lease.
Counsel.
In my answer, I have asked that you escrow, the rent was,
Oh, this is all kinds of sleazy and wrong. It's too boring to explain, but just to affirm what you're wondering, yes, it's sleazy and wrong, and you can't do any of this stuff.
paid with a minor amount withholding that was still a balance due on repairs. The rent was paid this past month, and in my answer, I have asked you to set up, I've asked you to stay the eviction. I've asked you to escrow the rent under the same way you did in our other case. And I've asked you to transfer the case to the circuit court.
Not happening.
Your Honor, their notice for possession and eviction is exactly the counter complaint that they made to Judge Aldzai several months
That's
ago.
because you filed there.
I understand, but it's the same for judicial efficiency.
It's late.
It's the same circumstances. It's the same claims. It's the same.
May very well be, but that's for the court to decide. And I'm declining to do what you're asking regarding this case at this time.
You mean to transfer?
I want to know where the escrow is.
The escrow is in my,
She's familiar, although I don't know if I did the last case with her or not. I can't remember. She's familiar, but if I did, it was a while ago.
it's all paid out. The escrow funds are all paid out to the contractors. They paid this month's
Counsel, do you
rent.
see the problem here? Do you?
Well, I know you want me to see the problem, but
Then that must be the answer is no.
no.
You took client money in
I withheld rent.
and then dispersed it.
I withheld rent.
Which is number one, wrong.
Under the landlord tenant.
But you can't on your own then disperse it.
They
If
dispersed.
they,
Erica Ward signed those contracts and paid those
Miss
contracts.
Tosh, if as a tenant, they elect to set up an escrow account to put their rent into, show me the authority that then permits them or their agent to disperse those funds.
This was not.
Show me authority for that. Because I'm going to tell you, you're not going to find it.
My first request was that you stay the possession,
This case.
repossession.
Denied. Next request.
Motion for you to set up an account for the rent to be escrowed into and paid out.
I am not going to have a problem ordering escrow.
Okay.
What I am going to have a problem with is that I think because of what you just explained to me, that you are a necessary party that has to be joined. Because if they set up their escrow account with you.
No, they paid
Yep. And that puts an end to your representation, which is probably a good thing for your clients.
the rent to me. I did not really, there's no formal escrow account. I held it so she could pay.
Then that's another problem.
Oh my goodness. Oh,
Yes, oh my goodness, because the law has to be followed. They can't just give the rent to somebody else. If they're going to properly withhold, and I would have hoped you would have informed them of this, they have to set up an escrow account. Outside of the fact, then, they are really obligated to then let the landlord know where that escrow is.
I
And
did.
they are. But then they can't disperse it.
How can they pay for the necessary repairs that he did not perform over a year and a half?
File suit and get an order. And the fact that you're a party to that, I think it's going to make you a party to this action, because if that money doesn't appear, I think, I'm not suggesting that it occur, but I think plaintiff has a claim as to you, because you had to take that rent as an attorney, as an agent, whatever. You took that in trust. It's like if they had decided to withhold rent and they went, like most people would if they're going to do this, they go to a bank, they set up the escrow account. The bank can't then, if it's set up as a true escrow account, they have to direct that it's paid out. But that's not what's happening here.
Under landlord-tenant law, tenants are allowed to withhold rent. They don't necessarily have to set up an escrow account. They just have to inform the landlord where the money is, where the money
I
is held.
appreciate you giving me a lesson on
I'm not
law that
giving,
I've been doing.
I'm not,
Here's the problem. This stuff is highly regulated. You can't hold client funds in trust for client and then do whatever the hell you want with them. It's essentially commingling. It's bad, bad, bad. You can't do this crap. When I disperse on a case, for instance, I'll get a case and I'll get a check from the insurance company. I put it in my client trust account, and then there will be some money that's owed to the medical provider, say the doctor that performs surgery or the hospital or whatever. And then there's money that's owed to these people or whatever. And I have to do this with a statement of settlement and show where every penny went. I can't just willy-nilly do whatever the hell I want with that money in the meantime. It's got to be in the account until it's dispersed directly to the people it's supposed to be dispersed to. Nothing else. No deviations. None.
I read the Michigan state law about tenants and what to do about landlords who do not make necessary repairs for the health, safety, and welfare of their tenants, which in this case includes horses and boarders. I also did file suit. We filed suit in circuit court for breach of lease, for every single breach of lease that the tenant has performed over the last.
Is there anything else?
No.
Because you're not listening to anything I'm telling you.
I am hearing you.
You're not listening.
I am listening, and I'm giving you an answer when you say you file suit, and I tell you that I did. We did file suit. No. Do you want anything else from me? Do you have a?
I got a ton of questions, but I never get an answer. So you can have a seat. Anything else in the plate?
Your Honor, I would just say that the withholding of the rent is against the lease agreement, and placing in the attorney's escrow and paying contractors and paying for supplies at Lowe's and Home Depot is completely, it's wrong. And what what I put in the motion to compel payment of rent is that the case law, we're disputing, and we filed an answer disputing that, we're on the hook for some of these repairs. But longstanding Michigan common law provides that tenants' duty to pay rent is independent of the landlord's alleged covenant to repair in the commercial context. And that's the Reum case from the Michigan Supreme Court, and Detroit Marine Terminals is an unpublished.
Yeah, but statutorily that's been changed. So I understand the common law.
In the residential context, Your Honor.
I see what you're. Go ahead.
Your Honor, and that's all I have, unless you have any questions for plaintiff.
Is there another hearing set before Judge Outside?
Yes.
What day?
On November 7th.
I believe it's Wednesday, this upcoming Wednesday.
This coming Wednesday.
There's nothing wrong with common law. You see a bunch of soft sits and stuff say things, and they use the term in a way that it's not meant. Common law just means you're speaking of case law as opposed to statutory based law. So he's saying the common law, the way we've done this via case law for years is this. And then Judge Simpson said, yes, but a statute's maintained that, or has changed that. And he's like, not in a commercial context. And that's all that's going on. There's nothing strange about that.
The basis for the termination in this case is really breach of their obligation, in a lot of ways the obligation to pay rent in this case. I think, as I was trying to point out there, as this court views it, additional problems and concerns regarding the use of this money. So what I am going to order, which is also unusual to order these cases, but I will order it, that the defendants are to provide to the court an accounting of the.
No, I get it. You see it abused so much. You're wondering if the attorney's adopting the soft sit sense of it. No, he's adopting the actual sense of it. But I understand why it would bother you after watching soft sits.
Escrow paid into whatever the account was and the disbursement. Yes, Ms. Toe.
Your Honor. In my answer to plaintiff's complaint to recover possession of the property and my motions to eviction, motion to transfer case and proposed order proceeding, I explained everything, and I included as the very last page, which was exhibit, I can't read my own writing, B2, and accounting.
Which one was it?
That was defendant's answer to plaintiff's complaint. It was filed on October 24th. They got a copy. The last page of that entire filing is an accounting of expenses paid.
Are the receipts attached?
I don't have, I can get the receipt.
I want the receipts attached. I want a very detailed accounting of what came in.
Yes.
What was paid out.
Yes.
I want receipts for all of those transactions.
Contracts, we have paid receipts. And an explanation of everything that the money went for.
Have you done now?
And the term of the lease under which.
He wasn't really asking. What he was saying was shut up. But you're so damn thick. You didn't get that obvious clue. Read the cues, woman. Read the cues.
That expense was made.
Are you now done? presume yes. So I want that accounting. I am also going to order, how much is the base monthly rent?
5,500.
I mean, she starts with this notion that they have a duty to maintain the horse farm, which I don't know that they do or don't, as a matter of a commercial lease in the state of Michigan. They may or may not. I don't know. That's probably a good legal fight. But she presumes it's the case prior to a court ruling, and then does a bunch of inappropriate crap based upon the assumption that she's right on an issue that I'm not confident she's right on. And even if she was right on, you can't do that stuff with your trust account under any circumstances. There you go. There's the summary.
Per month.
Per month. Was November paid to you?
The check was sent.
When was the check sent?
The check was paid out of Bank of Ann Arbor's bill payer on the first of the month.
And at this point, you haven't received a check. Give me 55 divided by 4 times 3.
Divided by 4 times
Times 3, yes. 41.25. I'm going to order that the defendants are deposed with the court with a.
The judge asking her to turn over the accounting on that is literally forcing her to admit likely ethical violations and file them with the judge.
In 7 days.
And he knows it.
Escrow for November prorated at the amount of $4,125.
Yeah, that'd help.
And then are deposed with the court $5,500 on the first of each month, and that rent ordinarily would be due. How long will it take you to get that detailed accounting to me, Mr.
I'll have it to you tomorrow, Monday.
Oh, Simpson can't stand her. But in Judge Simpson's defense, she's hard to like.
You've got a hearing before Judge Outside next week.
Wednesday.
So I will then adjourn these proceedings. See where that has got to November 21st.
Is that before Thanksgiving? No,
It is.
it is. Is it the Wednesday before Thanksgiving?
Thanksgiving.
Because they don't know.
27th.
Your Honor,
She's awful, and she is far superior to that knucklehead that does bankruptcies in Florida that I recently did. He did his own appeal. She's way better than him, and she's terrible.
I am
Somebody hired him.
scheduled to be out of town with my family and relative in Portland, Oregon,
What days?
from the 20th to December 3rd.
Then fine. Then fine. We'll see you next Friday.
Next Friday.
Yep, the 14th. At what time?
2 p.m.
2 p.m. in person. All right.
Yeah,
By that time, the
that about
escrow,
covers
the first payment of the escrow should have been paid, or some verification of receipt, and then we will go from there. Thank you.
Thank you, Your Honor.
Thank you. Thank you.
Please switch your video off. Otherwise, the host will assist you with that. Courtroom 2, good afternoon. Who do we?
All right, this is mostly I just this isn't a great appearance, but I came across it today, and I was flabbergasted. I was flabbergasted as one of my they said in one of my prior videos by the outfit. I don't know what the deal is. She might have just been arrested and pulled in this, but if she chose to wear this to court, you got to be kidding me.
We have first?
Position 3, Miss Atkins.
Okay. And who's the prosecutor at the present time?
I believe this case belongs to Miss Williams, but it's myself and Miracle Williams on this morning.
Judge.
Handling the case,
Right.
or afternoon, I guess, handling the cases.
All right, Miss Williams. I'm waiting. Oh, all right. I was waiting for Mr. Tucson
has.
Howard to log in. He has logged in. Are you set to go, Mr. Howard? Or
This one's my fault, and I don't even want to take credit for it because I'm going to tell you right now it sucks.
would you like?
I'm
Okay.
good.
All right. So we have position 3, Deanna Atkins, accused of battery family violence from November 7th, 2025, case number 25 CR 7198E. Ms. Atkins, you've been advised of your rights. Your attorney is Mr. Mirzajadin. And any priors, Mr. Howard?
Second, 2025 sale of marijuana.
Thank you. Ms. Williams, what's your bond recommendation for Ms. Atkins?
One moment, Your Honor. My apologies.
Okay.
Wait till you see the footwear. You're going to love it.
I had
Not
this
very
one at the
long.
bottom. Yes, Your Honor, this would be a $4,000 good bond.
Mhm.
No further violent contact with Justin Wright. Stay away from the incident location and a one-day anger awareness.
This is her second arrest, right? Is that correct?
Yes, Your Honor. It looks like she may qualify for a signature bond.
All right.
Yeah, my thought process here was horrible outfit and a little quality time with Judge Lal. Let's do it.
Mr. Mirzajadin, first of all, before I begin, is there a Justin Wright on Zoom that wants to be addressed? Justin Wright. Okay. Do you have any comment about the stay away and no violent contact?
Yes, Your Honor. We would have no objection to a no violent contact. We believe that Ms. Atkins and Mr. Wright are still on good terms and do wish to continue to have contact. And as to the stay away order, we would object to that. It is Ms. Atkins' place of residence. Her name
Oh, yeah, we good, Judge.
is on the lease. She pays all the utilities. And Mr. Wright only recently has been staying there at the as Ms. Atkins is allowing him to stay there. So we ask there not be a stay away put on Ms. Atkins, and of course ask for a signature bond as she is eligible for.
Don't they share kids?
They do, I believe, share one child.
Okay. This is going to be a 2,500 signature bond through pretrial services level 2. Ms. Atkins, you will report to pretrial services twice a month. I'm going to grant you a signature bond, but you must comply with the following conditions. If you fail to comply, then your signature bond will be surrendered and you'll be back in jail. You're to have no further violent contact with Justin Wright, which means that from this point onwards, no physical altercations, no verbal altercations. If there are any altercations in the future and the police arrive, you most likely will be arrested first without any questions asked. You may return to the 1957 Vesta Avenue location to continue to live with Mr. Justin Wright. Also, within 30 days of being released, you will enroll in what we call a family violence intervention program. This is a series of 24 weeks of classes, and you will enroll, attend, and complete all the classes and pay for them as well. No illegal drugs, no alcoholic beverages, and definitely no firearms. Your next court date will be sent to the Wester Avenue location. Thank you.
We got position 4, Mr. Carter.
Dejane Carter or Dejan
Those are
Carter is
straight
accused of
jammies.
battery, family violence.
That's straight jammies with the slippers. This next one's short and it's excruciatingly horrible. It's absolutely terrible. You guys want to let it run?
From November 7th of this year, case
It'll make you wanna
25
crawl your eyes
CR
out.
7192B. Mr. Carter, you've been advised of your rights. Your attorney is Mr. Mazarjadin. Any priors?
Second
Mr.
arrest, open theft by taking to state court.
All right. Thank you. And Ms. Pope, and what's your bond recommendation?
Yeah, the state's asking for a $2,500 signature bond through pretrial level 1, FFIP, no further violent contact with the victim, but we are asking for a stay away from the location, no weapons, drugs, or alcohol while on bond.
All right. Is there a Carlicia Burdett on Zoom?
State did speak with her, and I do believe that she was intending to be on Zoom. Just give her a moment. I guess she's not here.
Okay.
I'm sorry, I'm here.
All right. Please unmute and start. Well, you need to start your video as well. All right, Ms. Burdett, please raise your right hand. Is that your right hand? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
You shared 3 children with Mr. Carter,
Yes.
and you wish to not have him return to the home?
Yes.
Okay. Thank you. Mr. Mazarjadin, you may mute your screen, Ms. Burdett. Yeah. Mr. Mazarjadin? Yes, sir. Any objection to the stay away?
No, Your Honor, I've spoken with Mr. Carter. He has arrangements to stay with his mother in Fairburn. We would just ask if possible that Mr. Carter not be mandated to go to the FFIT program, an anger management class, if that is a possible alternative for him.
All right. This is going to be a 2,500 signature bond through pretrial services. I'm going to make it a level 2, not a level 1. He will have to report to pretrial services twice a month. No violent contact with Carlicia Burdett, which means that there cannot be any physical or verbal altercations between the two of them. If there are, the police get involved, Mr. Carter will be the one back in jail. He's to stay away from 222 Tuskegee Street, I believe. Is that in Atlanta? Yes? Okay. And he's allowed a one-time visit to the property with a police officer to retrieve his personal belongings. But after that, he needs to update the court with his new residential address, which I understand will be his mother's home. I'll allow for third party, since there's no violent contact, I'll allow for peaceable transfer of the children for visitation. If Mr. Carter, Ms. Burdett, are you married to Mr. Carter? You need to unmute.
They are
Yes.
married. Your Honor.
Are they married?
Yes.
Yes.
Okay. So I'll allow for transfer of the children, but it must be no breach of peace. It must be nonviolent. And
exciting and new.
we will see Mr. Carter at the next court date. We will send him summons to his new address. Thank you. Oh, no illegal drugs, no alcohol, no firearms.
Okay. Hey, Your Honor, I'm sorry. So I can just bring the kids to his mother's house without contact with him?
No, it's no violent contact. In other words, you can speak with him, you can have contact with him. He just cannot engage in any physical or verbal altercations with you. Now, did you want no contact or did you want no violent contact?
Okay.
All right. Okay.
Yeah, I'd rather not even have any contact. I'd rather just take the kids to his mother. Okay.
I'm sorry. Ms. Burdett, you're not being very clear.
You know, I may have mistaken the note that I had.
Okay.
She's
I'm
asking for
sorry.
no contact.
I thought I heard no violent contact.
I did say that based on what I saw from our note where the victim witness advocate spoke to her, but I just heard her ask for no contact at all. So the state would ask for no further contact.
All right, Ms. Carlicia Burdette, last time, do you want Mr. Carter to stay 200 yards away from you and not communicate with you in any way, form, or manner? Or did you want to have it in such a way that he cannot have any violent communication and no violent contact with you? Do you want to ever speak with him for the next few months?
We can do no violent contact.
Are you certain? All right, we'll go with no violent contact. If you're not comfortable, please reach out to the solicitor's office and tell them you want to amend it. Thank you.
Is she like not understanding, or is she just trying to be difficult? What's going on there?
Thank you.
I got position 7, Mr. Gresham.
Okay, this is Lab Matt's fault. We're gonna go back over there. It looks like we still have the slippers going on. Let's give it a try.
Deputy, I'm sorry, which position is this?
Position 17, Mr. Ragland.
Okay. Mr. Ragland's case is 25 CR 7211E. His name is Kajwani Isail Ragland, Isail. Incident date appears to be November 6th of this year. There are 6 misdemeanor offenses. There are 5 counts of battery, family violence, and 1 count of theft by taking. Mr. Ragland, you've been advised of your rights, and your attorney is Ms. Pinto. Any priors?
Yeah, he got 9. Got an open giving false name out of Clayton County. Got an open battery DV, 3 counts. Cruelty in the 3rd. Simple battery DV. It's 24 CR 006 688 F. 2022 battery, simple battery conviction.
All right. So Ms. Champion, this case has to be assigned to Division F. So right now it's assigned to Division E. All right.
Actually, Your Honor, the DA's office has agreed to accept this case for a felony transfer for aggravated assault.
Okay. So this is going to be transferred to the DA's office. All right. Ms. Pinto, would you still like to address bond pending the transfer?
Yes, Judge.
All right. So Ms. Williams, what's the recommendation?
And Your Honor, I would like to put a few of the facts on the record. Our victim is Skylar Bryant, Skylar, last name Bryant. Stated that she and the defendant were upstairs in their room when she asked him what was going on while he was talking to to his child's mother. He got upset and began punching her multiple times, slapping her multiple times, choking her until she reportedly saw stars and felt that she couldn't breathe, as well as kicking her multiple times, causing bruises and scratches around her neck. Her face was swollen, along with her lip having a cut on it as well. He also, as she advised, bit her as hard as he could, causing swelling to her fingers before he damaged the door, leaving wood all over the floor, witnessed by the officer, before leaving and taking a PlayStation 5. Your Honor, in this case, the state recommends a $10,000 good bond for 5 counts of battery family violence with $2,000 on the theft by taking, to have no further contact with Skylar Bryant, to stay away from the incident location, to have to do an FVIP class, and to have no drugs, alcohol, or weapons.
All right. And Ms. Pinto? Well, let me see. Skylar Bryant, you on the Zoom? Did you want to address the call? All right, Ms. Pinto?
Yes, I do. Yes, I do. I'm sorry. I just was able to get on here.
Okay, you need to start your video, please. And you need to turn around and face the window because I can only. Good heavens, are you dressed?
Yes, ma'am. I have a shirt on.
Put your shirt on properly. You're in courtroom.
It's on properly. That's how it's made.
Then go put on something else. Switch the video off. We'll come back to you.
Okay.
That's how it's made. Goodness. Okay. All right, Miss Pinto, pending Miss Schuyler's
Yeah.
wardrobe amendment. What would you like to tell us?
Thank you, Judge. Mr. Ragland is 22 years old. He's lived in Atlanta his entire life. He has one child who turns 2 years old on the 20th of this month. His whole family is here in Georgia. He's a graduate of Benjamin E. Mays High School. The pretrial recommendation in this case is a UJR with supervision level 3. We would ask for a signature bond, or originally this was only 2 charges, Judge. I would like
simple battery and yep, you're correct. Yes, correct. It was a simple battery and a theft by taking, but gosh, how it's bloomed.
It certainly has. However, it remains one alleged victim and one incident, Judge. So I don't know why it's so many charges. But if the court is not inclined to give a signature bond on the case, we would ask for something as low as possible, $2,000 max. And I will note that the residence is Mr. Ragland's residence. He reports that the alleged victim is not on the lease there.
We both are on the lease.
If the court requires a stay away, he does have somewhere else he could go. And then he also wants to starting that by taking, he reports that that phone PlayStation.
I'm sorry, Miss Pinto, you're breaking up.
The theft by taking, that is his own PlayStation. So he wants the court to know that as well.
And also, Your Honor, if I may, just briefly,
Just
a
one
number.
second, Miss Williams, just 1 second.
Yes,
Mr.
sure.
Carla, please mute your screen. Go ahead, Miss Williams.
Yes, Your Honor. One of the reasons for the additional charges were there were actually, it's one incident date, but it's a series of attacks because one stopped, and then when other witnesses arrived, the attacks began again, based on what our victim described as the defendant getting upset that the witnesses were believing her side of the story, Your Honor. So that's one of the reasons that that second attack with that second set of injuries that she had, Your Honor, that's one of the reasons for the additional charges.
Okay. All right, Mr. Carla, you may unmute now and raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Do you have multiple devices open?
No, I only have one.
Is somebody else there with a separate device?
No, I'm by myself.
Okay. What would you like to tell us?
I do feel like a lot of it was a misunderstanding, and I do feel like, well, one thing, we're both on the lease. His name is on the lease and my name is on the lease, and I have the lease to prove that. The second thing is that a lot of I do feel like that he shouldn't have to stay away because this is his home. This is both of our home, and I feel like this is something that we could work past. So I don't want him to be issued a stay away if that's possible. That's all I wanted to say.
Okay, thank you. I just need to relook at this. So, Miss Bryant, it says over here that y'all been living in that place for 2 weeks.
Yes, we just moved here.
And how did
We literally just got on our feet and got an apartment.
And both of you on the lease? Miss Will?
Yes.
Okay.
Yes, we are.
And how long have y'all been dating?
probably like 5 or 6 months now.
Okay. According to the officer, you were struck with a closed fist on the left side of your face near your temple. He allegedly put his hands around you. You thought you were about to lose consciousness. According to the warrant, this was on the body cam.
Mhm.
And then the defendant left is when you called the police.
Yes.
Your
Ugh.
sister arrived at the location.
She came after the police left.
Right. And then later the defendant came back.
She came after the police left. The defendant came back the day after.
I'm
My
just
sister was
reading what
already
the
there.
officer reported. I'm not here to correct the officer. I'm just reporting what was in the warrant.
I see absolutely nothing's changed since I used to prosecute this 500 years ago. People are exactly the same.
Oh, okay, I'm sorry.
Apparently, you were allegedly attacked again by Mr. Ragland. And apparently your index finger was bitten. The front door was apparently damaged. And really, the PlayStation 5 doesn't really bother me. Is that your device?
I bought it, but I bought it as a gift for him, so it's his device.
Okay,
I like to think I don't look a day over 300.
that's fair enough. So based on what I've just read, you are comfortable with him being home with you?
Yes, I'm not
I
scared.
need your face on the camera, please.
I said yes, I'm not scared.
Okay, thank you. Mr. Ragland, as you have already been informed, the district attorney's office has accepted this case as a felony matter. I appreciate the fact that Ms. Bryant is here in support of you, but what is stark is the disturbing allegations set forth in the warrant. On the battery family violence count 1, that's going to be a $12,000 surety bond. On the remaining charges, they are going to be a 1,000 signature bond through the jail. So that's going to be 12, 13, 14, 15, 16, 17. This is a $17,000 split bond. You are to have no further contact with Skylar Bryant. You are to stay 200 yards away from her. You're not to communicate with her in any way, form, or manner. Even though you are on the lease, the fact that you both cohabitate at that location doesn't mean that you have a right to return to that location pending this case. So you're going to be required to stay away from 3379 Stone Road, apartment B5, the entire location. You're allowed a one-time visit with a police officer in order to retrieve your belongings. And then within 30 days of release, you must update the court with your new mailing address. No illegal drugs, no alcoholic beverages, and definitely no firearms. You're not allowed to own, possess, or have any firearms on you or near you. Your next court date is going to be November 20th, pending the transfer to the Superior Court as a felony matter. Thank you. Next case, please. Thank you, Ms. Bryant. You're free to go.
All right, there we go. That was ugly. That was Lab Matt's fault. It was actually kind of interesting, but I mean, it's depressing. It's depressing. So I had a couple of depressing clips from yesterday. I had the poor grandma with the pots, who I did a bunch of cases on, but it's just starting to bum me out, because it's sad. So I thought I won't do that for a Friday happy hour. And then I saw that horrible attorney, and it just gets nasty with Judge Simpson. They just can't stand each other. And I frankly, I don't blame Judge Simpson in this circumstance. But and both of those, I'm like, nah, those are too nasty for a Friday happy hour. And then I'm laughing at myself because today I'm like, well, there's no court. So so here you get me unloading all my depressing clips. And thanks to Lab Matt for adding another one. Maybe I'll just be a weekly thing, the Saturday depression stream. That's what happens when you don't have material. All right, behave yourselves. Thanks for coming out. I appreciate it. As usual, I'm not bailing you out. I'll see you soon.